Everyone, great to see you. Happy Earth Day. And this is the beginning of Climate One during San Francisco Climate Week. I'm so excited to have you here and have the Attorney General with us. We're in the San Francisco Bay Area. I'm Greg Dalton, and I'd like to acknowledge the Ohlone and other indigenous people who have stewarded these lands for 10,000 years. Currently, there are many tribes and bands who are working to restore their culture, heal from historic trauma, and protect their traditional territory. I've had the pleasure and honor of getting to know some Coast Miwok people near where I live in the North Bay, and it's been a fabulous experience. I encourage you to go beyond gestures and land acknowledgements and get to know indigenous people where you live, because they are still here. We're recording today's conversation for the Climate One radio show and podcast that drops every Friday. You can subscribe Apple, Spotify, wherever. Right now, if you're not a subscriber, you can do so right now on your device. We have a lot of exciting things happening here on this stage this week. Tomorrow, guests include California Environmental Justice Alliance, Mary Rose Tarouk, her and Air Resources Board Chair Leanne Randolph, California Natural Resources Secretary Wade Crowfoot, and San Francisco Environment Director Tyrone Jew. He's played a key role in San Francisco Climate Week. And tomorrow, very special guest, Mr. Heat Pump, right here. We'll answer all your questions about heat pumps, because you know you want one. And on Thursday, guests include Lieutenant Governor Eleni Kounalakis, CEO of the California Chamber of Commerce, Jennifer Barrera, and State Senators Scott Wiener and Nancy Skinner together here. Tickets are available on our website, climateone.org. At the end of today's conversation, we will take questions from the audience, and please write your name and a couple of a concise question there on the card, and Megan will produce it, and she'll collect those and ask you to, then we'll get to as many as possible. If you're watching on live stream, then please write your questions in the comment section, and we'll get to them as many as we can. So we're going to be really excited today. We've, the SF Climate Week here, the first one, maybe it's not the first one. Many of you probably flown to the one in New York. I've never actually gone back to that one. Now we have our very own SF Climate Week here. So now it is my great pleasure to welcome California Attorney General Rob Bonta. All right. Sorry you're going to be here with Mr. Heat Pump tomorrow. So you filed the civil lawsuit that alleges ExxonMobil, Shell, Chevron, ConocoPhillips, BP, and importantly, the American Petroleum Institute have known since the 1960s. I actually think there's evidence they knew in the 50s, right, that burning fossil fuels could warm the planet. Then instead of alerting the public, they chose to downplay or outright deny the effects. Can you give us an overview of the suit and what it alleges?
Absolutely, and wonderful to be here. Thanks for having me. The short of it is that these fossil fuel companies and the API, the American Petroleum Institute, they knew about global warming and predicted with terrifying accuracy where we would be today with extreme weather and global warming and climate change, and they lied about it. It was bad for business. They knew internally, they acknowledged internally with memos and conversations the truth of climate change, but externally to the public, to the world, they lied. And they denied climate change. And they didn't just fail to talk about it. They had a very sophisticated, strategic public relations approach to how they denied it. They hired a firm, and they created front groups, and they placed and planted op-eds, all saying the opposite of what they internally acknowledged. And so this is a climate change deception case. We have filed it in San Francisco Superior Court. We are the biggest geographic entity and biggest economy to sue these fossil fuel companies for this conduct. We think it's a game changer. We think it's a massive transformational moment in terms of accountability. And we believe in a simple premise. One, you shouldn't lie to the people of this state, of this country, of this world. And two, you should be held accountable and pay for the damage that you created because of that deception and because of those lies. So a cornerstone of our case is our public nuisance claim, which has a remedy of an abatement fund, a fund to pay for mitigation and abatement to address climate change repercussions that have harmed so many of us. Of course, now we know we're seeing droughts and floods and wildfires and superstorms, and homes are being washed away or burned, and farms are being impacted, our infrastructure, our roads.
Can I just jump in there, though? Public nuisance sounds like, noisy neighbors next door and dog poo on the sidewalk. It doesn't sound like a serious thing. Nuisance doesn't sound like the serious things, but that's, so what is it about nuisance as a legal term? Because nuisance sounds like, you're a pain, but, it's not a big deal.
It's very serious, and it's been applied in major actions like this in the past. So it is essentially a harm to a community or a neighborhood that's been created by a single entity. That is exactly what's happening here with fossil fuel companies creating harm to all of Californians and beyond. And it's not an unprecedented novel approach. It's been used with tobacco. It's been used with opioids. It's been used with lead paint. Other entities, big corporate entities that have harmed people with a product that they knew was harming them, and continue to perpetuate it and push it out into the marketplace anyway. So it's a tried and true approach, and the abatement fund could be seeded with billions of dollars from the fossil fuel industry.
Okay, and we'll get into that later. So nuisance is more serious, in a legal term than it means to kind of the average person. There's also fraudulent, you're claiming business practices, damage to natural resources, and product liability. So this seems like you're actually going after throwing a lot of different things to see what sticks.
That's it. There's four buckets of legal claims. There's the public nuisance claim. There's a series of claims around fraud and deception and false advertising. There's a failure to warn products liability bucket of claims. And then the fourth is a special cause of action that is unique only to the Attorney General of the state of California to be able to protect our natural resources when they're harmed by an entity. So four buckets, the most broad sweeping set of claims ever in this space, again, brought by the largest geographic entity and economy.
Right, and we'll get to some other states are doing this as well. But first, the key really is, back to that phrase from the Nixon era is what did they know and when did they know it? In 1991, Shell produced a video called The Climate of Concern that lays out quite accurately, I think this is more than 30 years ago, what they knew, how they knew it, and the science that was going on. It's quite a remarkable video that shows, again, this is from Shell Oil, produced this video. Let's hear a clip.
These models contain many uncertainties, but they forecast that by 2050, global mean temperature could have increased by at least 1.5 degrees, possibly near 4.
Snow melt there.
This may not sound much, but what the computer modelers are looking at is the possibility of change at a rate faster than at any time since the end of the Ice Age. No two scenarios fully agree. But their strange, mesmerizing images of possible futures have each prompted the same serious warning. A warning endorsed by a uniquely broad consensus of scientists in their report to the United Nations at the end of 1990.
So that's a 1991 video from Shell Oil saying, it's happening, we know it, it's science, humans are causing it, it's bad. Your reaction, have you seen that before?
I haven't seen that video clip, but not shocking and very consistent with the evidence that we have set forth in our complaint. Our complaint's very thorough, over 135 pages. There's a set of 15 to 20 pages which lay out in excruciating detail that will make your blood boil, the facts dating back from the 50s, 60s about what the fossil fuel companies that are defense in the case, what they knew when they knew it, how they acknowledged that, citations and quotes to internal memos, to internal discussions, and then what they did instead to lie to the people, to bypass clean energy pathways and opportunities for carbon capture and development of other technologies in pursuit of billions of dollars in profits, and their business model has been very successful. They have captured billions of dollars in profits while socializing the costs to the people of California, America, and the world.
And we've seen this before. A lot of this follows on the tobacco playbook with, delay, deny, et cetera. Or they go from deny to delay to deflect. There's lots of D words that come up here. And then in 1998, Big Tobacco agreed to a grand bargain and pay more than $200 billion over 25 years. It's known as a master settlement. Complicated, but there's similarities. Lots of states, and then they eventually rolls up into one big settlement. This happens in asbestos and other things.
Yep.
So how relevant is the oil precedent for how relevant is the tobacco precedent for what you're trying to do on oil?
Very relevant, and we can't talk about our lawsuit without talking about tobacco, without talking about opioids, without talking about lead paint. And the similarities with tobacco are striking. The use of front groups, the use of strategic public relations.
Some of the very
firms,
same lawyers.
The same ones. It's the same playbook. It's an off-the-shelf playbook used by corporations when they know about a fact that is very problematic to their business model, that they know that they're hurting people, and if people knew that, they would make different decisions, so they set about to lie. Merchants of doubt, undermining the science, and providing studies that they commission and op-eds that they place in key newspapers to suggest an alternative reality than the truth that they acknowledge.
Influencing elite universities with research funding, yeah.
By paying for the funding. So paying for their own studies. They don't like the actual facts, they pay for alternative facts. And it's wrong. And the pathway that tobacco took, where multiple entities worked together, teamed up, applied aggregated pressure over time and across geographic spaces. We're in the middle of that process now, I believe. Our entry, I think, opens up the floodgates for others to join. And if other states who are invited to join and other entities who are invited to join add their voice, then I think we get into the same place as we were with tobacco.
But there's a big difference between tobacco and oil, is that a lot of people never smoked, right? And everybody uses fossil fuels. I've owned an electric car for more than a decade. I still use fossil fuels. I still fly. So tobacco and oil are different in terms of, the economy runs on oil in a way that it never ran on tobacco. And we're complicit. You and I are both complicit. So how do you get to that?
I mean, it's not about who's using fossil fuels. Like you said, it's universal, it's ubiquitous. And that's part of the lie here, is to tell people it's okay to use fossil fuel because climate change is not real. It's not really happening. Or it's not happening as quickly, or it's not as urgent. Or we are now, today's greenwashing lies, our fossil fuel is actually clean energy. Natural gas is clean energy. Or we're in the middle of a massive transformation into clean energy futures when only 1% or less of their investments are actually in clean energy, and 99% remains with fossil fuels. So we are the state of California suing. California is a fossil fuel producing state. We're the home of Chevron. And both things can be true at once, that you can hold fossil fuel companies accountable for their conduct, for their lies, for the damage that they visited on the people of the state and this nation, and acknowledge the truth that got us here, which is that fossil fuels are ubiquitously used.
There's a difference also in the mechanism of harm. When I smoke a cigarette, smoke goes into my lungs, it causes cancer, right? We burn fossil fuels, it goes up in the sky, something happens, it comes down, and suddenly the San Mateo coast is eroding, and we have droughts, and so it's a little harder to, how do you know that this company or this refinery caused this flood or this damage, therefore to assign damage in a court case?
Yeah, that'll be part of what we have experts to talk about, the depth and the exact scope of the damage, the causation that exists. There is no doubting climate science and climate change, although the whole business model of the fossil fuel companies has been to doubt it. If you believe in facts, evidence, science, and data, you can't doubt it. And so that will be a part of the discussion, how much each entity pays into the abatement fund, how much Chevron is responsible, and how much Shell is responsible. I'm happy to have them pointing the finger at one another to talk about who's more responsible than the other. But the damage in aggregate will be clear. The impact on Californians, we have data that shows the impacts of wildfires, the impacts of floods, the impacts of superstorms. It is knowable. And so we will present that to a court and make our case.
Ben Santer is a climate scientist formerly at Livermore National Lab who kind of pioneer in fingerprinting. And he says that climate science in courts is kind of like where DNA evidence was 25 or 30 years ago. It was this complex science. People didn't know how to use it in courts. And now DNA evidence is kind of common and used all sorts of ways, right, to get people convicted or let out. He says climate science will be like DNA science. It'll be, understood and used in courts. So tell me a little bit about this, this fund. You just mentioned sort of you're going to sign, who pays into it. Where does it go, and who decides where the money goes? Because that's often a big issue. Is like, okay, got a big pot of money. In smokers, it's pretty clear. Like it's gone toward education, stop kids from smoking. Where would you direct the fund if you were successful?
This is something that will be the product of discussions at the time that we secure the abatement fund, which is not today. It'll be a couple years down the road.
Might be decades, some people say.
We don't think so. We think 3 to 5 years. We want to move expeditiously. We entered this case now because the pathway to a substantive ruling to actual judgment day instead of procedural hurdles is within reach. For the last 5 years, there's been a debate about whether these cases should be brought in federal court or state court. The decision has been made in the Ninth Circuit in the Western region.
And the U.S. Supreme Court has kind of cited and also not, said, keep it in state, which the oil companies wanted in federal.
That's correct. They did not take the appeal from the oil companies to the U.S. Supreme Court. In doing so, assured that we could move forward in state court. So the abatement fund will be used based on the need to address all of the variety of harms of climate change, to abate and mitigate. It could be things like cooling centers and clean air centers, forest management, seawalls could be possible, water storage to address drought. Any of the challenges from drought to wildfires to floods to superstorms that have a mitigation, those are potential areas for investment.
And you've worked on environmental justice. What about communities that have been most harmed? Because we have 5 refineries here in the East Bay. They're concentrated in a certain area. It is downwind from Pacific Heights and Marin. It is in certain communities. What about those communities that have been frontline and harmed most by fossil fuels?
Absolutely. The communities that are hurt first and worst, that are under-resourced and overburdened, that live at the intersection of poverty and pollution, are top priority for relief and for support. It's an appropriate allocation of resources to help those harmed the most and who have the least ability to respond and provide them substantial resources up front.
By one count, there are more than 30 cases against oil companies filed by states, cities, jurisdictions, and tribal nations. As you said, there's been a lot of procedural, try to slow it down. Massachusetts and the city of Honolulu have moved past a lot of those motions, and they're for dismissal and reached pre-trial discovery phase. Now, this is where things get interesting, because this is when boxes of documents start to show up and emails get revealed. So what are you looking for in discovery? Because these are the sort of, when the so-called smoking guns come out and things get really interesting. Yeah,
it's exciting. And that there's 30. I think you'll see double, triple, quadruple that in terms of entities that sue as they learn more about the case and they see the momentum that we're building, and they see that you can get to the substance and hold accountable these fossil fuel companies. I'll say first that when we sue, we feel we will win in court at the time of suit. That we've done our due diligence, we've done our investigation, we've developed the factual case and bases for our claims, and we feel we could go to trial very soon, that we don't need discovery to prevail. Discovery is another way to build on our causes of action, maybe identify other causes of action and amend the complaint, to add belt and suspenders to the facts that we already have. So we're looking for more smoking guns. And I say more deliberately. We have smoking guns. We have those memos that show that in the 50s and 60s, these fossil fuel companies are acknowledging the future of climate change and extreme weather and global warming. They knew then where we would be today, and they said it, and we have documents that prove it. So are there more documents? Is there additional indication of that theme of knowing about climate change and lying? Surely there's more, and we expect to find some of those documents in discovery, and what becomes available in other cases, to the extent it's not confidential and it's public, becomes evidence in other cases.
Though, sometimes in the American system, a lot of the most egregious transgressions are legal. A lot of what happened in the great financial crisis of 2009 was legal, right? So proving lying is one thing. The part for me that were the strongest case, which, the biggest obstruction, again, may not be legal, is policy obstruction. I talked to one lawyer for Chevron who said, look, this should not be in the courts. Congress should address climate change. It's too technical for the courts. And I said, I agree with you, and if that's the case, you really believe that, then the American Petroleum Institute, which you're a member of, should stop trying to smear electric cars and slow down progress and all these sorts of things. So isn't it possible that what they did is part of our system to slow down policy that's not in their interest? That's legal. That's okay by our system. It's not illegal, right?
Oh, no. I mean, the fossil fuel companies are allowed to make their comments known to policymakers, to lobby them, to petition their government for the positions that they want. That is completely separate from this lawsuit. The fossil fuel companies want, and shared with you exactly what they've been sharing since day one. They want you and others to wrongly believe that this lawsuit has something to do with policy. It doesn't. This is a lawsuit based on a cause of action and a legal claim and the facts that support it that lead to a remedy. Here, public nuisance, abatement fund, and our other three buckets of causes of action. Policy is separate. It is for Congress to deal with. It is for the legislature to deal with, and they are dual tracks that could pursue the same some of the same missions and outcomes if that's what they sought. But policy is for one arena. The courts is for causes of action and remedies. And so there's a defense in that the fossil fuel companies have asserted here called the political question doctrine, which says policy questions are for legislators and for Congress, not for courts. And this is policy, so therefore you should throw out this case. They have been saying this wrongly and falsely since day one, that this lawsuit is a policy suit because they want to have it dismissed based on their political question defense. It is not. It is, it wasn't for tobacco, it wasn't for opioids, it wasn't for lead paint, and it's not for oil. They're not special, they're not different, they are subject to the courts and causes of action that are based on facts that get remedies in court.
So how much of this, your suit, is affected by the other cases going on? There's one, Held versus Montana, which that's very specific because the Montana state constitution, because of some reforms in the 70s, says there's actually a right to clean environment in Montana that we don't have in California. Some people are trying to get that in the California Constitution. There's Juliana, which is the public trust doctrine, trying to take something from water and apply it to air. And that's been, in the Biden administration, by the way, is fighting that, just as the Trump administration and Obama administration did. So how much is this affected by an ecosystem, or is it just kind of each case and each state is very narrow and separate from the others?
It's part of an ecosystem. It's part of an ecosystem of litigation that has impact litigation. Some of the biggest changes in our society have occurred through litigation. See, for example, Brown versus Board of Education. This is a place where change can occur based on existing law and violations of that law and the remedies that ensue as a result of the lawsuit. So, Montana, with a special Montana constitutional provision, a case should be brought in Montana under that constitutional provision. It's not available in California. It can only be brought in Montana. You should do it. And
it was upheld by a conservative state court. It was upheld by a conservative state Supreme Court in Montana.
Yes. And so, we should bring justified claims that are supported by the facts, claims that have a strong legal basis. But the courts are a place for holding folks accountable, like fossil fuel companies when they skirt accountability and force people to pay while they're taking billions of dollars to the bank, and they're lying to the people and violating the law in the process. So I think more is more is better. I think any claim that is based on sound law and good facts that can hold the fossil fuel companies available are part of a broader ecosystem of impact litigation.
And some people say impact litigation is partly about chipping away what's called the social license to operate. These companies operate partly because society allows them to operate. And, whether it's gun manufacturers or opioid, et cetera, that can erode, and public support can erode for these companies. And that's one tactic. How much do you think about the social license to operate that could be eroded where consumers, investors start to say like, ooh, we don't want to be part of these companies. It's not so much about the legal case winning in court. It's about a broader social or even moral question. Do you think about the social license to operate, or are you just like, no, I'm focused on this case and these facts?
I mean, I think those are all part of the bigger picture. We are occupying one lane in this broader sort of discussion and dialogue about climate change, our global future, the role of fossil fuels in bringing us to the brink to where we are. We're taking the lane that we have. It's a lane of litigation and civil causes of action, seeking remedies to hold folks accountable for the harm they created and the lies they've told. There's a whole set of others, as we know, where socially conscious investment is a part of the theory of change. Do we have our big pension funds invest in fossil fuel, or do we divest? Or what do boards want from their companies? How are they going to hold these fossil fuel companies accountable? What do shareholders do and shareholder suits? Those are all separate from us, but they're part of the broader discussion. And then there's also policy and law being created in Congress and state legislatures throughout the state. So all different ways to address a problem that we are collectively facing, but we are in a very unique and distinct lane of litigation.
Right. It reminds me of your football game at your alma mater, the Harvard-Yale football game. The protesters flooded the field saying divest. Yeah, Harvard divested, Yale has not. So what do you... You were in the assembly before you were attorney general. If I had a magic wand and I said, you're CEO today, right now, for 24 hours of a major oil company, what would you do? What do you think the limitations on your power would be? If you're CEO, like, okay, what should the CEO of Exxon do, or any of these oil companies?
If I was a CEO, I would say we're an energy company, and energy can be created in ways that preserve our planet and ways that destroy our planet. And we should embrace the pathway that preserves our planet, protects it, and move away from fossil fuel and into clean energy, and be an extremely successful billion-dollar clean energy, sustainable energy, green energy company to provide energy for California, the United States, and the world. But we need, in the interest of humanity, our planet, responsible corporate action, we need to adopt a successful clean energy future.
BP tried that, became Beyond Petroleum, right? And Lord Brown, who I've actually sat with here on this stage, and you could say that they were flawed in their implementation. And part of the problem was that Wall Street, dirty still makes more money than clean, because dirty doesn't pay the full price of the pollution that they socialize and put into the atmosphere we're using as an unpriced sewer. So CEO Rob Bonta, you could say that, and I'm Wall Street, and I'm like, because you're not going to make as much money. So the system traps these individuals, which, and I think that, so don't we need to change the system? Because it's really the financial model that, any company that wants to kind of do more renewables, it's hard for them because of the economics of the system. It's bigger than as big and powerful these companies are, they're still in an even larger system.
The system is changing as we speak, under our feet. It is becoming more expensive to be dirty than clean. You know, this abatement fund remedy is billions of dollars to the bottom line of fossil fuel companies. That's a cost. That's a cost they have to report. They have to share with their shareholders. The divestment of pension funds and others, the Yales and the Harvards and their funds are costs. There are subsidies for investments in clean energy and green energy. So the economic point is an important one. I think that is becoming less imbalanced over time. But there's also just a corporate responsibility. Like, do you want a planet for your kids and grandkids? For your workers, kids and grandkids? Do you want to be part of the thing that ended our planet and our future? Or did you transform and change and embrace a clean energy future? And so, money doesn't talk about that, but that is an important part of how we behave in this world. And we look out for one another, and we believe in us and we and our shared society and our common future, as opposed to how many billions of dollars I have to report and that I can spend.
It also seems that the current CEOs, who are not the people who were leading and deceiving back in the 80s and 90s and saw that, are kind of trapped by the lies of their predecessors. If you're a CEO of an oil company and you said, like, oh, right, we lied, you're right, they would be sieged with lawsuits, right? So can you see how they're trapped by their own lies? And like, I don't know what the way out is, but they can't, if they admit it, then the lawyers, the trial lawyers pile on, and then there'd be all sorts of lawsuits. So they're kind of trapped. Can you see that?
I see what you're trying to paint a picture of, and I think that it's always appropriate to embrace the truth. Even if you don't want to say, okay, we are, here's an admission, I'm signing it on behalf of the corporation, you can take it to court, and, we admit it's admissible as an exhibit in a lawsuit. Mm-hmm. You can see what's happened in your company, see what the damage you've caused to the climate and to our world's future, and take a different path. And then you can leave it for the courts to decide the rest. You can, cooperate as you should, consistent with the law in lawsuits. Let whoever is going to appropriately bring a suit develop their evidence, and you can settle those cases or fight them if you want and go to court. But meanwhile, you can go forward and say, I'm not going to be part of the perpetuation of the lies of the past. I'm not trapped to also lie and maintain those lies and retell those lies. I can do something different. I can move us in a different path, a path that is responsible for our planet, and I think in the long term, as folks continue to put pressure on fossil fuel and its reliance, invest in something that's economically profitable by moving into clean energy.
ConocoPhillips is one of the companies you're suing, and I actually spoke to a board member of ConocoPhillips who's an amazing guy who doesn't like going to gas stations, drives an electric car, and says that energy companies are terrible at making money. Look at their return on capital for the last 10 years, and that they will not play a role in the energy transition because it's not good at what they do. They're not good at solar. They do these like multi-billion-dollar massive projects. He thinks they're ill-equipped to be part of an energy transition, and he's on the board of one of these companies, and he basically wants, to speak for him, you can listen to this podcast. It's called Two Surprising Voices. He basically wants the last oil to come out of the ground to be American, for American jobs. We do it better and cleaner than other places, and to make money doing it. My point is, like, these companies are not monoliths. They're like people with different interests. How much interaction do you even have conversations with oil companies, back channel, et cetera? Or is it kind of like, we don't talk to you because you're suing us?
Oh, we've talked to them. I've talked to the fossil fuel industry leaders in Sacramento as a legislator. I've talked to them as an AG. We take meetings. We have an open door policy. We listen. We're willing to learn. We're open-minded. We're interested in exploring pathways, co-creation of solutions. There's no hand saying we won't talk to you. We'll judge you from afar and sue you. We're happy to have those conversations. We're happy to listen to possible pathways for the future. But to that point about not being equipped, that's today. Get equipped. Bring the talent in. That happens all the time in companies as you need to be nimble and adapt. As the future, legacy approaches are not the ones for the future, and there's disruptors enter the marketplace. You have to adjust. So adjust. Don't say we can't do it. Get prepared to do it and make the change.
As you mentioned, California is an oil state, produces more oil than many people realize in the Central Valley. How about the workers? Because it's one thing to say that, the executives, Lee Raymond in particular, when he was head of Exxon, did a lot of obfuscation. But how about the people who are, working in the Central Valley? There's a transition for them. Sometimes they hear these conversations like, you think I'm bad. You think I'm a bad person because I work in oil, right? And this happens, so what do you say to the rank and file workers, who feel, wait, you're trying to sue my company and put me out of business? I'm out of a job.
The workers are absolutely critical, and solving that piece of the puzzle, critical. Often referred to generally as the just transition. I don't think anyone who works in oil is bad. I don't pass any judgment on anyone who wants to work and support their family. Many are getting good jobs in the fossil fuel industry, and they deserve good jobs in the clean energy.
Union jobs, well-paying, a lot better than the clean energy jobs are not union and don't pay so well.
No doubt about the fact that the fossil fuel jobs are often union and well paid with benefits and health care. We need to make sure that those jobs, that there's no loss, that everyone is continued to be made whole as the transition occurs. That could look like a number of different things. The most important thing is that we don't talk about it, we do it. That there are good jobs in wind energy, and that you get the same health care and benefits and pay and union protections, and then in solar or whatever else it is that we pursue in clean energy. It might mean that there needs to be some government subsidies to protect and support workers, to make sure that none of them are treated less than they are now in fossil fuel when they take a job in clean energy. Some folks, who may not have a lot of career left and for whom retraining might not be appropriate, maybe they just get a massive payout. That could be a wise investment in our future by government to be part of the solution and to support it with subsidies.
And one thing I'm keen on is geothermal, because geothermal is actually, we have a fair amount of geothermal in this state, and that's actually a place where oil and gas skills are transferable. And there are people, we've interviewed people who've gone from oil and gas to geothermal, and that's actually a very real pathway, maybe more for individuals than for companies. Your mother helped organize Filipino and Mexican American farm workers for United Farm Workers. How does that influence your work on environmental justice?
Well, one, to the last question we had, it makes me very sensitive to and supportive of workers, to make sure that they are treated with dignity and respect, are supported and valued and seen throughout this whole process. That's item number one. Number two is, my parent. I grew up in La Paz, in the headquarters of the United Farm Workers of America. My dad worked in the front office with Cesar Chavez. My mom in the preschool with Dolores Huerta. We were there in the early 70s. We lived in a trailer. My parents got paid $5 a week for their work with the United Farm Workers, and some of their work involved things that we might call environmental injustice today. The fact that there were workers working in extreme heat, or with exposure to pesticides, or without getting access to water breaks. That was environmental justice before it was environmental justice. And making sure that those disadvantaged communities, the communities that are, as I mentioned before, under-resourced, overburdened, living in communities where there's massive impact, of the pesticides and the challenges, that helped me become sensitive to and excited and passionate about doing climate action and making sure that we have justice as we pursue climate action that preserves our planet, and making sure that we always look through that equity lens and support our disadvantaged communities who are hurt first and worst.
Yeah, and those communities are, outdoor farm workers in rising heat. We don't have outdoor worker protections. Cal OSHA hasn't acted on that. I think our governor may have even blocked that. So looking ahead, we have some big ballot. Energy is on the ballot in November. There's an oil setback thing. Does that play into what you're doing? And what's at stake there? There's a ballot measure, maybe even competing ballot measures on oil setbacks in November.
there's an oil setback referendum on the ballot. We, at the California Attorney General's office, we write the title and summary for all state propositions. So that's what we focus on. That's our role. That's our lane, to write truthful, objective, fair, understandable titles and summary for the people of California to be able to review, understand, and make their voice heard on when they vote. I don't get involved in propositions until we are done with our job of writing the fair and accurate title and summary, until it's free and clear of any possibility of litigation. So
you're an umpire. You gotcha. You're an umpire in this.
I call balls and strikes.
There you go. Okay, how about this one looking ahead? You know, there's a possible change in administration. You will be the person that will defend California's waiver under the Clean Air Act to have stricter pollution laws, because our air here is so bad in the LA Basin and the Central Valley. What are you anticipating for a possible, situation where, usually California is kind of aligned with the feds, or sometimes we're like this and we go like this and we go like this, back and forth.
Yeah.
We may be entering in a period where the waiver is going to be, rescinded, which a lot of California's climate policy rests on our ability to have stricter standards here.
Yep.
What are you worried about looking ahead at November?
Let me first say that, with the Biden administration, I'm super supportive of the Biden administration generally. When we're talking about environment, so supportive of the great work that they've done to move away from the Trump era rules and lean into climate action that helps address our climate change problems. And as friends, it's sometimes important for friends to push friends to do more. California is always the most aggressive, on the leading edge, doing the most on the front foot, and we want to push other states to do something similar, our federal government to do the same, and other nations around the world. So that has always been our mantra. It's part of our legacy in addressing climate change, protecting our natural resources. Of course, my hope is that the Biden administration continues their great work and has 4 more years to do it. That is not the only possibility of the general election coming up in November. So we have to be prepared for an alternative. And I guess fortunately and unfortunately, we had 4 years to see what that could look like in an iteration, not the only iteration. It could be worse, it could be different in a Trump 2.0 administration, should that come to pass. But California and my office sued under my predecessor, the Trump administration, over 100 times for a lot of issues that that were high profile, like the Affordable Care Act, like DACA and immigration policy. But the majority of those 100+ lawsuits were environmental, and holding the Trump administration to account when they moved beyond their regulatory or executive authority, violated federal law, or infringed upon other legal jurisdictions, including our own. So we are prepared to do the same. We need to continue to lead this nation and this world. And if the Trump administration comes to pass and becomes an impediment and a challenge, we will stand up tall and strong and continue our pathway forward, including getting our waivers so that we can be even more aggressive than the rest of the nation when it comes to vehicle emission standards and other things.
Right, and the Heritage Foundation actually put out a report for what they plan for 2025, and it's much more ambitious this time than last time, what they're thinking about. We'll go to audience questions. Victoria asks, how do we engage the public in these legal matters? Should we engage the public in such actions?
I think the most important thing about our lawsuit is the narrative and the factual renditions it provides about fossil fuel companies knowing the truth about climate change and lying about it, and that it's akin to what tobacco did. So if you take away nothing else, you should repeat and tell your friends and your networks that the fossil fuel companies knew and they lied, and this is just like tobacco, and it is. And that's not a story that's well known, that has been socialized into the everyday person throughout California. It's a story worthy of spreading far and wide and greater understanding, so that people are informed, so that they're no longer misled by the lies, but they understand the truth of what happened and then can make their decisions accordingly.
So we've been talking a lot about big oil. Gas stations are what we see on many street corners, et cetera, and they're kind of easy targets. And we have in talking about what they knew and when they knew it, and their deception and policy approach in Congress and in courts. And there are a couple of questions about who's not named in your California's lawsuit. Phil Lee asks, what about coal and natural gas? Do you uncover similar behavior from them, and why are they not named? And John Tripp asks, are there fossil fuel entities not included in the lawsuit? And why were they left out? Similar question. So why just oil?
Yeah, in short, these are the worst liars. They're the biggest deceivers. They're the ones for whom we have a factual basis to support our claims. It is not a comprehensive lawsuit it doesn't seek to be a lawsuit against every corporate entity that's been involved in climate change, that's part of the fossil fuel industry. It's meant to target those that violate our causes of action in the most provable and clearest ways. So we have evidence and data about their lies. We have smoking guns and red flags in their own internal documents, and we have an opportunity to bring additional cases or bring other entities into this case should discovery that we talked about earlier lead to other potential defendants.
When a lot of, as I mentioned, there's like 30 suits out there from different counties, cities, et cetera. And California notably, didn't sue. Some cities and counties did, San Francisco, San Mateo, et cetera. And when I saw this suit, I thought, oh, he's running for governor. So it says something about the politics of, it says that, because there was a time in this country where going against energy was a political loser. David Axelrod and Rahm Emanuel famously in the Obama administration said, don't go there, it's bad politics. Now it seems to be it has swung the other way. So what do you think about what do you think about that and the politics of this?
I think the politics are going to be whatever they are, and you can't control it, and it changes from time to time. It's more important just to do do the right thing, do what is best for the people of our state. And I do want to say I'm very grateful for San Francisco, for Oakland, for San Mateo, for Santa Cruz, for the other states that sued before we sued. They were pioneers and leaned in early and hard and help us get to where we are today. And they continue to be our colleagues and our allies in this fight. We're fighting together. Many of the cases in California are coordinated here in San Francisco Superior Court, and we will be side by side sharing information, bringing the case together. For 5 years...
Are you thinking about running?
For what?
California's had Boxer and Feinstein for a long time. Now we have 2 male senators. Well, we're about to have we'll have 2 male senators. Is it time for a female governor of California? Are you considering running?
I'm going to answer that question in 1 second because I want to separate it from this lawsuit. It has nothing to do with this lawsuit. For 5 years, as I mentioned, there was a procedural fight about where the suit can be brought. Federal court, which honestly it was close to being outcome determinative, meaning less likely chance of success in the merits in federal court based on the law in that court versus state court. We sued as soon as we knew that we could bring this case in state court, where we always wanted to be. So the timing has nothing to do with politics and everything to do with getting to judgment day, moving past process and into progress on the substance, which is where we want to be. Since you've asked, I've been honored to be asked by many others and encouraged by many others to run. I'm very seriously considering running for governor, and there's a time when I'll make that final decision. That time is not now. The time now is to be the best attorney general I can, to fight on the most important issues to the people of California, make their fights my fights, be the people's attorney, including taking on the biggest fights like this one against fossil fuel companies. So that'll be a decision for the future, not today.
And we are out of time. Let's give our thanks to Attorney General Rob Bonta for joining us today.